The importance of the federal sentencing guidelines cannot be overstated in the federal system. Over 90% of all of federal criminal cases are disposed of either through a negotiated plea of guilty or a conviction. So therefore, the federal sentencing guidelines come into play in over 90% of the cases. When I first started practicing law in 1978, there were no federal sentencing guidelines. A judge had complete discretion how to sentence an offender. It could be from anything from probation to the maximum sentence provided by law. And it was at the complete whim of the judge as to where that sentence would fit within that range. It may depend on a lot of factors. It may depend on whether the judge was a hanging judge, whether the judge was an easy judge. It may depend on whether somebody was black, white, rich, or poor. It may depend on where the case took place. For example, in Miami, a kilo of cocaine is considered nothing. In Kansas, a kilo of cocaine may be one of the biggest cases I've ever seen. So there was a lot of disparity in sentencing. And many people, as well as Congress, thought that this was unfair. And were of the opinion that people that committed a similar type crime should receive a similar sentence. And therefore, Congress enacted the federal sentencing guidelines, which became effective November 1st of 1987. And the way these guidelines work is they attempt to score crimes mathematically, and they assign certain points, and you add up the points to come to an offense score. You also look at a person's background and what type of criminal convictions they have, and come up with a criminal history score. And the combination of those two factors leads one to the guideline range. Now, this guideline range is a range that a federal judge looks at very carefully as the sentence that would be given in the normal case. And at one time, these guidelines were binding, but the Supreme Court ruled otherwise, and that they're now merely advisory. What this means is that the judge looks at the guideline to determine the guideline sentence, but has it within his or her authority to give a sentence above or below the guidelines. So it's very important for an attorney to be very familiar with the guidelines, to not only be able to attack the offense score or the criminal history score, but to present to a judge why a sentence below the guideline range is appropriate, either because there's something in the guidelines that calls for a departure below the guideline range, or there is some reason for what is called a variance below the guideline range. I have been working with these federal sentencing guidelines since their implementation November 1st, 1987. And on many occasions, I have been able to obtain a very favorable guideline sentence, either by knocking down the sentencing guideline range, or by convincing the court that a downward departure applied, or by obtaining a variance. If you are charged with a federal crime, it's extremely important to get an attorney that is knowledgeable on the federal sentencing guidelines.